Hey, you guys, it's Susan. I'm going to go ahead and do a training on the listing agreement so that I can share it with you. I'm going to go ahead and share the screen now so we can get started. And one of the things that you'll want to have in front of you is the actual exclusive right to sell designated agency listing agreement. That's what we're going to be going over. All right, let's get in here and get this thing started. One of the things that you need to know is, of course, our agency policy. Our agency policy is that we practice designated agency. So what you need to remember is that until you ever have a listing agreement signed or a buyer's representation agreement signed, you shall never refer to any consumer as a client, because you must have a written signed bilateral agreement to call somebody your client. We also know that when we're working with sellers, again, we're going to use the exclusive right to sell designated agency listing agreement. For Tennessee forms, that form number, I do believe, is the RF 101. If you are working as a designated agent for the seller and a buyer calls you on your sign or on an ad that you have put out, you must not complete or negotiate an exclusive buyer representation agreement. You need to notify your broker right away so that buyer can have their own representation if that's what they want. If it's their desire to remain unrepresented, you stay representing the seller and you will be working with them as an unrepresented buyer. Okay, so let's talk about listing agreement. This is a Tennessee Realtors form. And before you go out on a listing appointment, there are several things that you need to ask the seller to be gathering for you. I'm also going to share with you a step-by-step process, if you will, of what to do on a listing agreement. So you want to see if the seller can get you a copy of their deed, their most current restrictions. Do they have any lead-based paint information if the house was built in 1978 or before? You're going to go ahead and let them know that it's a good idea to get a 12-month history of their utility bills. That's electricity and water. Also ask them to go ahead and make a list of the utility companies they currently use at the property, trash, cable, water companies, power companies, those kind of things. Also, do they have any contracts or bonds on the house right now? Do they have a termite agreement in place already? Any type of warranties that they will want to transfer with the property? If they have leased items such as a propane tank or security system or a water softener, they need to find out if those leases are assumable or if the buyer will need to apply for a whole new lease. And we need to know all this stuff up front so we know how to deal with things as we're going through the process and going towards closing. One thing the seller will also have to do is complete the property condition disclosure form. That is something the seller does. You, as the agent, should never fill out that form. If the seller has not lived in the property in the last 3 years, if it's an estate, if it's a new construction, if it's part of a bankruptcy, that would mostly be coming from the bankruptcy court. But there are reasons a seller could be exempt from filling out the property condition disclosure, and those are listed on the exemption form. So you will need to make sure the seller completes the property condition disclosure or exemption and the lead-based paint disclosure if it's needed, so that you can upload those forms at the time you list the property, you put it into the MLS. We do not put any listings in the MLS without the proper disclosures uploaded. That way we're exercising reasonable skill and care with our sellers, so that if somebody wants to make an offer, then they have all the forms that they need. If you have any questions about that, make sure and ask me. So the listing form itself, the first few lines is pretty easy. Of course, line number 1 is the brokerage, the listing company, and that's going to be the firm name as it's on file at the Real Estate Commission. And for Weichert Realtors SEM Associates, that's exactly what you would put on there, Weichert Realtors SEM Associates. The address of the company, you would put that there. The owners or the sellers. So that would be all the sellers that need to sign. You need to find out if it's an estate, who the signer is and who the executor is. If it's an LLC or a corporation that is the seller, you're going to need the documents that gives any of these people the right to sign to sell this property. The address of the owner or the seller, that is the mailing address, because it could be different from the actual physical location of the property you're going to list. Then lines 5 through 7 is the actual hiring statement. This is where they are going to hire us and give us the exclusive right to sell the property. It's very important that your agreement says that. And as long as you're using Tennessee Realtor forms, the Forms Committee in Tennessee will make sure that you actually have what you need in the listing agreement. Next up, we're going to talk about Section 1, which is all about the property, its legal description, personal property that stays, things like that. Lines 9, 10, and 11, and even 12 are pretty basic information: the physical address of the property, the city, the zip code, the county it's in, the deed book and page number. And if there's an instrument number, you could put that there, but not all properties transfer or track via an instrument or document number. The instrument/document number is not the tax ID, so don't put the tax ID there. On line 13, you would need to put the tax ID, the lot number, and the subdivision, and you can get all of that information off of the tax records, and you can search tax records inside the MLS under CRS tax record search there. Line 14 says, together with all fixtures, landscaping, improvements, and appurtenances, all being hereinafter collectively referred to as the property. You got to talk with the seller about each one of these things, what fixtures stay. And in a real estate agent's mind, if it's attached, it's a fixture. And that's basically true. There's some other things that the court will look at, but you need to discuss with the seller the items that are going to remain with the property. Landscaping, that's bushes, that's flowering plants, it's bulbs, it's rocks, it's all kinds of stuff. So you got to talk with them about that. Improvements are buildings outside of the main structure of the main single family home, if you will, or condo. Maybe there's an outbuilding, maybe there's a carport, maybe there's a detached garage, maybe there is a barn, run-in shed, something like that. And then an appurtenance is an incidental property right that goes with the property. Okay, so some of those are different types of easements: a gas lease, a water lease. Have they sold the mineral rights? You got to have these discussions. And then you get into the infamous pre-printed items, lines 16 through 25. This exact same wording is on the purchase and sale agreement. So you need to discuss each one of these items with the seller and make sure that you guys understand what's staying and what's not staying. Okay, so if things are going to stay that is over or above and beyond what's pre-printed here, you'll list those on lines 27 and 28. Let's say if the seller wants to leave the refrigerator, you would put something, as you see the language on line 27, side by side stainless steel Samsung super cool refrigerator. Don't just write refrigerator, okay? Then you need to make sure and transfer that information into the MLS. If something's not going to remain, as you can see the example language that starts on line 30 and 31, it says porch swing, master bedroom, curtains. Again, you need to put that stuff into the MLS in the public remarks and in the agent remarks. The biggest thing you need to remember about this is if the seller says something's not going to stay, when they get an offer, you need to make sure that those items are listed on the purchase and sale agreement in the section that says items that will not remain with the property. Okay, if not, you could find yourself having to buy something at that point. So please always ask questions. Leased items that remain with the property. This is where you can talk to the seller about their leased items. Okay, what's leased, Mr. and Mrs. Seller? And you write those items there on lines 33 and 34. They will also be filling out some information about leased items on the property condition disclosure. If they have an exemption, though, they won't be filling that out there. So you need to make sure and enter leased item information into the agent remarks on the MLS when you input into the MLS. Section 2 is the listing price. It's pretty basic. Hey, this is how much you're going to list it for. And then the term. Now, you have to understand the wording of this agreement. It says this agreement shall be valid from the date this agreement is fully executed by all parties, and that is the effective date. And it's going to go through some month and day of some year, and that's going to be the expiration date. And the reason I have fully executed by all parties highlighted is so that when you get over to the last page of this document, you're going to have to be able to see the date so you know what the listing date is, okay? And so it's extremely important. And I'll go over this again on the back side of this. If you're using a digital signing tool, you need to make sure that the date is in the date blank, okay? Don't just let it be dated in the signature block. And again, we'll talk about it some more. And so it says here, if a contract to purchase, exchange, or lease is signed before this agreement expires, the term hereof shall continue until final disposition of purchase and sales agreement, exchange agreement, or lease agreement. So something you have to remember as the listing agent, depending upon which MLS you have your listings in, some MLSs, once it's marked pending, contingent or pending, it won't expire off of the market. Other MLSs, it will expire. So you're going to have to know what your MLS rules are, what will happen, and make sure that your listing does not hit expired status while it's under contract. Now, lines 41 through 44 is a delay in marketing, if you will. And it says, seller directs broker to commence marketing of the property for sale to the general public on the effective date or on some other date. Now, all MLSs have different rules concerning what we might call a coming soon, okay? If you're going to do a coming soon, you must abide by the MLS's rules. The main thing that you need to understand in all the MLSs that I'm aware of, if it is a coming soon, if they allow a coming soon status, it cannot be shown by anyone to anyone until it goes active in the MLS. Now, if the seller says to me, Susan, you know, it's Thursday and I'd really like to wait until Monday to start doing some showings and things, that to me is not a coming soon, okay? So if it's Thursday, I would go ahead and list it. And then you've got 24 hours once you put the sign in the yard to get the listing in the MLS. And then I would just put in the MLS that showings won't start until Monday. So it's a little hairy right there. So please talk to your broker when you're talking about not listing it and getting it in the MLS, because there's some very specific MLS rules that you have to go by. The carryover clause, you might remember this from pre-licensing. The carryover clause, our office policy is 180 days. And what that means is if anybody comes back to that property to buy it, that seller is going to owe you a commission for 180 days after the listing expires. If any buyer that you directly or indirectly made aware of this property comes back to them. Now, right now, we're not having this problem. Things are just kind of selling and going crazy, okay? But when the market shifts and the market changes, you may see houses lingering on the market 30 days, 60 days, 90 days, 120 days, 180 days. That's what you're going to see. And things were going to get a whole lot different. So, but get into the habit of putting 180 days as a carryover clause. Possession of the property, you've got to talk with the seller about that. You can talk about the fact that most buyers in our area want possession of the property at the closing. So as soon as the property closes, they want the key so they can move in. And you could put at the closing, or you could put something like the wording you see here on line 52, that it's negotiable as per the purchase and sale agreement. Number 5 is extremely important. It is up to you as an independent contractor to make sure that you know all the requirements of each loan type, FHA, VA, conventional, etc. And if the seller or the seller's property will fit into those loan products, okay? It's the seller's choice what they offer as far as financing goes. But I will tell you that in our area, we still have FHA buyers, we have VA buyers, we have conventional buyers, we have THDA, Tennessee Housing Development Agency loans, we have rural development loans. Okay, and so it is the seller's choice what type of financing they accept, but they got to be careful that they don't not offer all types of financing if the property will fit into that financing, so that they don't cut their buyer pool. And if you have any questions about that, let me know. The best thing for you to do is to sit down with a lender. You've got to be able to recognize when you go in to list a house, if that house will go FHA or VA or not. First of all, if it has any peeling paint, if the floor coverings are gone or ripped or something's wrong with it, and you can see the actual subflooring, those houses are not going to go FHA, VA, and even might not go conventional these days. So it's good to talk with multiple lenders so you can stay on top of these things. Next up, we're talking about compensation. It is the policy, our office policy, that we list at 6%. Okay, we don't want you going lower than 6%. If you feel the need for some reason that you need to go lower than 6%, you have to get the approval of your broker. Okay, so, and that 6% is based on the total sales price of the property. Okay, that's lines 55 through 61. Line 62 through 70 is an amount if they decide to lease their property and not sell it. Again, in the market we're in currently right now in April of 2020, that has not been an issue for a few years now. But there was a time that the seller's property did not sell in a timely manner, and they had to move on and go on and do to a new job, whatever it was. And they would say, hey, Susan, let's just lease it. Let's get it leased so somebody else can make that mortgage payment, and I'll lease something over here on the other end where I'm going until we can get it sold. So you may end up putting zeros in the blanks at line 63. Totally up to you and the discussion you have with the seller, and always watch the market for market trends so you will know what to do in this scenario and what to discuss with the seller. So then we have some language, if you will. And I know that reading through these forms with folks is not the thing you want to do line by line, but let me reiterate something to you. You need to read this line by line to the people you're working with. If they say to you, I've listed and sold, 12 properties, I don't need you to read it line by line. You need to make a note in your record. I don't even care if you write it down in the special stipulations of the listing agreement that they asked you not to read it line by line. Okay, you got to do something to protect yourself, because it never fails. They're going to come back and say, well, they didn't tell me that. They didn't tell me that. So you have got to know what's in these documents you're using so you can explain it to them. Now you need to go over this with the seller, because it says on line 72, the seller further agrees to convey said property by warranty deed to such buyer, free from all assessments, liens, and encumbrances. That's a question. Mr. Seller, do you know if there are any other liens against your property? There could be mechanics liens, there could be IRS tax liens. You got to talk to them about this. And it says, but it can be subject to all restrictions of record, if any. So, Mr. Seller, What are the restrictions in your subdivision? Do you have a copy of those? Those are the kinds of things you need to discuss with the seller. So the next statement is pretty simple. It says the compensation payable for the sale of property is not set in any manner other than between broker and seller. And we've always heard that commission is negotiable. It is, but that negotiation comes from the brokerage, the broker and the brokerage, okay? You as individual real estate agents can't go out and just set commission rates. That is set by office policy. And that's what I was telling you earlier, what our office policy is. The next line or two talks about fair housing. We do not deal with real estate agents who are discriminatory. So you should not be discriminatory in any shape, form, or fashions with anybody. If the seller ever asks you to be discriminatory as far as the seller lease of their property, that's a violation of law. You need to tell them that, tell them you will not do that, and you need to notify your broker right away. Okay. Line 78 through 88 talks about some of how the seller is obligated to compensate the broker in several different ways. If they unlawfully fail to close the property, like if they go under contract and then they say, well, I've changed my mind, I don't want to sell. They're going to have to get an attorney, first of all, to get out of that purchase and sale agreement. And then their attorney probably will need to advise them on your listing agreement also. So don't just be letting sellers out of listing agreements because they ask you to. You need to go and talk to your broker. So if that happens, if they ask you to release them from the agreement, again, talk to your broker, because here in this paragraph is where it says that the seller agrees to compensate broker in an amount equal to the compensation which would have been due and owing broker had the transaction closed or the lease been fulfilled. Okay, so it also says that they agree, if you will, starting about line 83, 84, that they will agree to pay costs incurred by the broker to market the property, cancellation fee, or any other sums that may be due the broker. So it's the individual designated agent cannot make decisions about the contracts between the brokerage and the seller. Just remember that. Responsibilities of the parties, very important. You read this. Line number 90 says broker is hereby granted the authority to do all this stuff in here, okay? Advertise it, put it in the MLS, put it out on the internet all over the place, okay? Let it be syndicated out on, as it says on line 94, publicly accessible websites that are sponsored by or affiliated with the MLS, okay? If they're lawfully receiving listing information, we can put it out there. We will also provide timely notice of MLS status changes. We'll use all of our best efforts to produce a buyer, and we can divide compensation with other real estate licensees for cooperation in connection with the seller lease of the property. Right here on lines 97, 98, and 99, actually, basically to the end of this paragraph is very important to talk to the buyer, or I'm sorry, the seller about, okay? So starting on line 97, all the way over to the right, it says broker shall offer a cooperative compensation to any agent who is a member participant of any MLSs in which property is listed in the amount of some percentage of the selling price or the monthly rental amount or some flat fee. So let me stop right there for a second. So we don't deal in flat fees, okay? So you get to put in the blank and discuss with the seller what's going to go in line number 99. There is no rule that says that you have to split the commission, okay, 50-50 with anybody. So for training purposes only, I'm not trying to set commission rates anywhere other than in my own office. If someone out of my office is watching this video, you need to abide by your broker's set commission rates. In my office, let's say that we listed for a total of 10%, and I wanted to pay the selling office 4%. I would put 4% right there on line 99 and keep 6% for myself. Okay, so it says we're going to offer on line 98, offer cooperative compensation to any agent who is a member participant of any MLSs in which property is listed in the amount of blank percent of the selling price to a selling agent or facilitator who is the procuring cause of the transaction. Okay. Broker may offer a cooperative compensation to an agent who is not a member participant of the MLSs in which the property is listed. In the event that broker elects to offer a cooperating compensation to an agent who is not a member participant in the MLSs in which the property is listed, it will be in the amount of blank percent of the selling price to a selling agent or facilitator who's the procuring cause of the transaction. So the first blank at line 99 is what percentage of the total commission are you going to give to the selling agent when they are a member of the MLS where you put the property. The second number is line 104 is what percentage of the commission are you going to give to an agent who is not a member of the MLS. Now, why does that make a difference? So let's talk about a couple of things. If they're a member of the MLS where the property is, then they got a lockbox key and they can get in and they can show it themselves and they can let people in that the buyer may need to let in, the inspector, the appraiser, whatever. They got a key, they can get in there. If they're not a member of the MLS, they won't have a key. You're going to have to work a little bit harder. So talk with your broker and talk with them about what they think should go in these blanks, so you can fill them in and talk to the seller about it and let them know why you're doing things. It says on line 106 and 107, in this event, broker shall notify seller in writing that a cooperative compensation is being offered to that non-member participant agent, which you are doing by filling in the blank at line 104. Then this is important. Seller will assist broker in any reasonable way in selling property and will refer to broker all inquiries regarding this property during the term of this agreement and any extensions or renewals thereof, and authorizes broker to provide final sales information to the MLS for the purpose of compiling comparable sales data reports. So this is all very important that you talk with the sellers about this. Then it goes on to authorize the broker to do things, place a sign on the property, a lockbox on the property, to remove all the other real estate signs if anybody had it listed before, to disseminate the property condition disclosure, disclaimer, exemption, MLS profile sheet, lead-based paint disclosure, to have photographs and videos and audio recorded, advertise the property on the internet. Just do, as it says here on line 116, such advertising as broker deems appropriate. If they give you any photographs, videos, or any other, as it says on line 117, copyrightable materials, then they grant you what is called a non-revocable license to that material, and they give you the authority to grant the license to the broker's MLS for storage, reproduction, compiling, and distribution of that material. Then I love this line 119. Seller shall allow the property to be shown at all reasonable hours and otherwise cooperate with broker. Again, line 120 says, seller agrees that broker is authorized to receive on behalf of seller all notices, offers, and other documents incidental to the offering and sale of the property, which is covered by the agreement. Seller agrees that such receipt by broker may be deemed to be receipt by seller if such documents so provide or if the law requires. Now, I've got that underlined in red there on line 121 and 122, and I have a little note to the side here on the right that says the PSA, that's the purchase and sale agreement, defines notice that way. And I put a little picture of the way notice is defined in the purchase and sale agreement so that you will understand and they will understand that if somebody sends something to you as their agent at 3 o'clock in the morning, then notice has been delivered. Whether you've opened it or not, notice has been delivered. And it says that in the agreement that that is the same as delivering notice to them. Okay, if you got any questions about that, talk to your broker. Then lines 124 through 126, this is extremely important. Okay, it says in response to inquiries from buyers or cooperating brokers, broker will follow seller's lawful instructions on the disclosure of the existence of any offer and or disclosure of terms and conditions of any offer. And it relates to the Code of Ethics Standard of Practice 1-15. So you've got to talk to the sellers about how they want you to handle multiple offers. And you need to put in the special stipulations section of the listing agreement what they tell you you can or cannot do when it comes to multiple offers. And this is to protect yourself. Let's take a look here. Here's what the listing agreement is talking about. In the Code of Ethics, it says in Standard of Practice 1-15, realtors, in response to inquiries from buyers or cooperating brokers, shall, with the seller's approval, disclose the existence of offers on the property. You are not supposed to be telling any agent, any other agent in your office, outside of your office, anywhere, that you have any offers on any listing that you have, unless the seller has given you the authorization and the approval to disclose the existence of those offers on the property. Let's go back to this section. So right here at 124 through 126, it says, you, broker, we will follow the seller's lawful instructions. So you got to say, Mr. or Mrs. Seller, do you want me to make disclosure of multiple offers? And they're probably going to say to you, well, what do you think? You're going to have to know the pros and the cons for disclosing offers on a property, okay? And there's a broad range. The pros are they could get multiple offers and they would be a bidding war and their price would get driven up, okay? That's a pro, right? Well, the cons are they could get multiple offers, they could get in a bidding war going on, and the price could be driven up. That's a pro and a con. Because some buyers will say, look, I don't want to get involved in this bidding war. That's okay. They've told us they have offers. I'm not even going to go on and make an offer. Some buyers will say, yeah, I want to make an offer. I'm going to make it $75,000 over list price. And then may have an appraisal problem on the back end. So you got to explain that to the seller. You've got to know how to explain all these things to the seller and let the seller make an informed decision about whether they want you to disclose offers or not. If they decide they do not want you to disclose offers and another agent asks you if you have any offers, all you have to do is say, I'm sorry, the seller's not giving me permission or authorization to make those disclosures. But the main thing you have to do as the listing agent is you have to go into the special stipulation section of the listing agreement, and you have to write something like this, lines 124 through 126. Seller does not give designated agent or brokerage permission to disclose offers on the property, or seller does give brokerage and designated agent permission to make disclosures, but you've got to do something to protect yourself. All right, we'll talk about that again when we get to special stipulations. Foreign Investment and Real Property Tax Act, this is kind of like capital gains taxes. If somebody is a foreign national, even if they have a green card, they may have some responsibility for this tax. I have no idea. You have no idea. You're not a tax professional. You've got to tell them that it's their responsibility to seek independent tax advice prior to any closing date regarding the FERPTRA tax. That's it. You don't get into a big discussion with them about it. Then we get this whole hold harmless and limitations on brokers' authority and responsibility. So remember, we had those paragraphs before that authorizes the broker to do all this stuff. Well, this is saying seller agrees to carefully review the information on the multiple listing profile sheet and to complete either the Tennessee Residential Property Condition Disclosure, Disclaimer, Exemption form, and to sign said documents. Okay. So one of the things that you need to do once you get the listing, you get it input into the MLS and the pictures uploaded. You want to send the sellers the MLS sheet and ask them to check it for errors. Make sure it has the right stuff in there, that you've selected the right stuff. Mistakes can happen, or if they see something they would like for you to change. Okay. They're also going to complete the lead-based paint disclosure. It says, if required by law, right now, April 2022, it is still required by law for sellers to make lead-based paint disclosures. Then lines 140 through 143, seller has not advised broker and or his affiliated licensees, hereinafter agents, of any defects in the property or the improvements located thereon, except as shall be noted on the multiple listed profile sheet and the Tennessee Residential Property Condition Disclosure Disclaimer Exemption or Tennessee Residential Property Disclosure Form signed by the seller. Seller is not aware of any other defect or environmental factor which would affect the value or the structural integrity of improvements on the property or the health of future occupants. And that's basically a definition of adverse facts. Then it says on line 145, I love this first part, seller agrees that seller shall be solely responsible for any misrepresentations or mistakes on the listing data wherein seller has supplied such information on the attached multiple listing profile sheet. Are you attaching that? Tennessee Residential Property Condition Disclosure, Disclaimer, Exemption, or Tennessee Residential Property Disclosure Form and the lead-based paint disclosure form. And then you have what I have highlighted in yellow, lines 148 through 152. It's a hold harmless statement. It's very important you read this stuff to the seller, okay? And again, line 152, seller is not aware of any other defect, environmental factors, or adverse facts as defined in Tennessee Code Annotated 6213-102 concerning the property. So anybody watching this video, I'm going to challenge you to look up Tennessee Code Annotated 6213-102 and read the definition of adverse facts. Here we go. This statement was added a couple of years ago because, you know, it got to where every time you go in a house, your video and audio recorded, there's just stuff going on. And the seller has the right to do that in their own property. But you need to let the seller know that they're responsible for complying with state or federal laws when it comes to the usage of video or audio recording devices while marketing or showing the property, and that they need to seek legal advice regarding their rights or limitations related to their actions. And they're going to look at you and go, well, can I or can't I? Don't answer that question. Don't answer that question. Tell them, oh, you know, I'm not an attorney. I'm sorry, I can't answer that. Okay. Don't answer that question. That's why we put that in here from the Forms Committee. That's why it's in bold language. Okay. Lines 157 through 164. And I know I'm going a little bit fast through this, but that's okay. We'll get through it. Seller authorizes broker and or his affiliated licensees to conduct showings or open houses of the property. Seller additionally authorizes broker and or his affiliated licensees and any duly authorized key holder key entry access to the property. And I have a note here on the left by lines 157, 158, 159, and it says home inspectors or appraisers. I get people all the time saying to me, you mean you let home inspectors go into a house by themselves with the buyer? Yeah, I do, because the listing agreement says they can. It says any duly authorized key holder. So anybody that is an affiliate member of the association is a duly authorized key holder. So they have the right, and the seller is giving them the right to go in the property and do what they're supposed to do. Inspect it, appraise it, whatever they're supposed to be doing. And this also is another authorization for you to put the lockbox on the property for those key entry showings. And then this last highlighted couple of sentences, well, maybe that's just one big long run-on sentence there, lines 160 through 164. It says that the seller represents that adequate insurance will be kept in force to protect seller in the event of any damage, losses, or claims arising from entry to property by persons through the above use of the key, and then they agree to hold us all harmless. So here's something that you gotta talk about at this point in time. When you're right here talking about the lockbox and people coming in and going through their house, tell them that they must always, always, always lock away where it cannot be seen, jewelry, firearms, weapons of any kind, anything that has meaning to them as far as something, this is a gold coin that my grandfather left me. Prescription drugs, you got to tell them that stuff needs to be put away and locked away at any time while the house is listed for sale, because you just don't know what people will do. Okay, and it's time to have that discussion with them. Again, more things that the seller acknowledges and agrees that the broker can do. And first one's really important. May show other properties to prospective buyers who are interested in seller's property. Okay, so you have a buyer that's looking in XYZ price range and you show them houses in that price range, including your listing. You don't want the seller to turn around and sue you because you showed the buyer other properties and didn't make them buy, in quotation marks, their property. Then section B is a little mini disclaimer. We're not experts. We are not an expert with regard to matters that could be revealed through all these different things here. It says that in 2 places at least in this document, line 167 and 175. Seller acknowledged that broker is not an expert. You're advised to seek independent expert advice. Also, you will use the RF 304 disclaimer notice with all sellers. Okay. Seller, it says the seller acknowledges and agrees that broker C shall owe no duties to seller nor have any authority to act on behalf of seller other than what is set forth in this agreement and the duties contained in the Tennessee Real Estate License Act of 1973. And I've written down the agency laws there, and that you're required, and the seller acknowledges that you're required to make certain disclosures by law or by the National Association of Realtors Code of Ethics. Next up, again, expert assistance. So we're not experts over here, and over here we have, as it says on line 182, considerable general knowledge of the real estate industry and real estate practices. Broker is not an expert in more stuff. Okay. RF 304, the disclaimer notice, always use that. If you provide, look at lines 185, 86, and 87, 185 all the way over to the right. If broker provides names or sources for such advice or assistance, broker does not warrant or guarantee the services and or products obtained by client. You need to always use the RF 711 vendor list when you're recommending any person, period, for anything. Okay, please remember that. Agency. And we've done all kinds of classes on agency. The listing agreement actually goes through again all the agency definitions and the rule, the duties owed to all consumers and the duties owed to clients. And that's what you're going to see over the next few slides. I'm not going to spend a whole lot of time here because we've talked about agency a lot. If you need more agency discussion, get with your broker. When you fill this listing agreement out and everybody signs it, you become what is defined as number 2, which I have a big red box around. Okay. If your firm's policy is designated agency, you will become the designated agent for the seller. Okay. That's what you're going to be. And when I'm talking to the seller about this stuff, that's what I am. As soon as we sign this agreement, I will be your designated agent. Okay. Gives them the definition of adverse facts. Remember earlier, I challenged you to go get the definition of adverse facts. So you could cheat and get it right here. All right. So you need to understand how confidentiality works also under the agency laws. These are the duties that you owe to all consumers, and you need to explain to the seller, Mr. and Mrs. Seller, even after I list your house and I am your designated agent, if a buyer calls on the sign in the yard or on an ad that I've put out on social media or somewhere on the internet or in some magazine somewhere, I still owe these 7 duties right here to any consumers that makes an inquiry on your property. Okay. I owe them to you and I owe them to them. Now, Mr. and Mrs. Seller, as soon as we sign this document, I will owe you these additional duties. If your company is a full service licensed company, like my company is, so Weichert SEM Realtors, you're listening to this, number 3 will never pertain to us because we are a full service company. We are not a limited service firm. So when you're talking to the seller, a lot of times, I'll be really honest with you, I put a big X, and I know you're not supposed to write on the forms, but I put a big X right over this, and I tell them, we don't practice limited services. So we don't even have to worry about that, Mr. and Mrs. Seller. But number 1 and number 2, I will owe you those duties as your real estate designated agent once we sign this document. Seller's authorization. So this is where number one is where your name would go on line 264. If you have a team, okay, if you are working with someone else and there is a team, then the names of all the team members are here on this line. And this is where the managing broker is appointing you as the designated agent. Number 2 says that if something happens to the designated agent on line 264, that the managing broker, if necessary, can appoint another licensee to be the designated agent. Number 3 says that if, please look at the bold italicized language on lines 271 and 272. If the designated agent, that would be me, you, whoever's name's on line 264, if we have a buyer's representation agreement, then we will default or change our agency status to facilitator. Please, I'm going to read to you what it says. Lines 270, all the way to the right. I'm not going to read the name of the section. The designated agent shall default to facilitator status for all showings or transactions involving the same designated agent for both the seller and a prospective buyer. That's the only time you have to default to facilitator. If you're representing the seller and a buyer that you do not know other than their phone numbers 555-123-4567, you just met them, they just called you, why would you leave a seller who has put all their trust in you to sell their property and default to facilitator status when you don't know that buyer at all? Okay. And if you don't understand how this is going to be or needs to be working, then you need to sit down with your broker and have a discussion. Okay. If by chance, though, you've been working with a buyer and you have a buyer's rep agreement with them, and lo and behold, they become interested in a house that you have listed, then yes, you would need to default to facilitator status at that point in time. Or if you're just getting ready to list the house, maybe you do an agreement to show property and let the buyer see it to see if it's something they want to make an offer on before you actually list it. And you wouldn't have 2 representation agreements in place. But whatever the situation is, this gives you the opportunity to change your agency status, which you have to be on top of this and confirm it in writing before you go under contract. And the form is the RF 303. Okay. You have to change your agency status with the form RF 303. You've got to put it in writing what you're doing. Even though they're saying at listing time you can do it, you still have to do it in writing. This is the form, notification of change in status or agency relationship. So this is the form that you fill out if you are going to change your agency status. Section 12 says that we can get earnest money for them, accept earnest money for them, okay? And that we are going to forward it to the party that's authorized to hold the funds. And so we can absolutely collect earnest money on behalf of the seller. Let's say it's one of those companies that don't hold earnest money, okay? Always offer for Weichert to hold the earnest money. We will always hold the earnest money. If someone insists that it be held by a title company, you're going to need to execute the RF 482 which I have a note there on the left side by the line numbers. And the seller's going to have to sign saying that it's okay for a title company to hold the earnest money. And the reason that is because title companies are not bound by the same rules of the Real Estate Commission as we are. So we have got to make sure earnest money is handled appropriately in accordance with the laws and the rules. Title, it says here that the seller shall convey the property by good and sufficient general warranty deed. So they've got to have a good deed on the property. 14 is a home protection plan or a home warranty. You know, we don't see a lot of those in this crazy market we're in right now in April of 2022. However, discuss this with the seller because this could be an extra layer of protection for sellers, okay? You should have brochures of home protection companies, home warranty companies in your office. You should know what they consist of. Basically, you don't have to know everything about them at all. That's why you have the brochures there. You could list those also on the RF 711 vendor list and let them decide which one they want to use and want to offer to the buyer. Because here's the scenario. You close. 4 days after closing, the compressor goes out on the heat and air unit. The buyer, the buyer's agent, and anyone else that hears about it is going to say, well, they knew something was going to happen with that. You know, that I'm sure they knew that there were problems with that. If you have this home protection plan and you go ahead as a seller of property and have your heat and air unit serviced, which that's something I recommend too, then this is an extra layer of protection for the seller. If somebody wants to call some attorney somewhere and you end up in front of some tribunal, the seller could say, well, you know, Your Honor, that's the reason I bought them a home warranty, because HVAC units don't come with a sticker on the side of them that says that the compressor is going to go out in April of 2022. But I wanted them to have a little extra protection. Is it going to get them out of trouble? Who knows, especially if they knew about it. But it is an extra layer of protection for, you know, $600. For $600, peace of mind. Peace of mind. That's what I'm saying. So don't just automatically check the box that home protection waived. Talk to them about them. Just talk to them about it. Then we have all the other legalese, if you will, the other provisions that this is the binding effect, the entire agreement, is it assignable or not? That's a question for you. Okay. It can only be assigned, a listing agreement can only be assigned with the written request of both parties. But there's other laws that surround a listing agreement too. And the state of Tennessee is the governing law and venue. This is where also at lines 302 through 306, especially number 4 at lines 304 through 306, you can talk to them about days and about how to count days and things like that. 307 through 309 is best just to read this to them. If any portion or provision of this agreement is held or adjudicated to be invalid or unenforceable for any reason, each such portion or provision shall be severed from the remaining portion or provisions of this agreement, and the remaining portions or provisions shall be unaffected and remain in full force and effect. It's pretty self-explanatory. Then you get down to the whole fair to housing thing again. I'm going to tell you right now, don't discriminate. Anybody and everybody deserves the right to live where they want to live. Lines 313 through 318, these are legal documents, okay? Please look at line 315, the second sentence there in this statement, or maybe the third sentence in this statement. Neither the broker nor any agent or facilitator is authorized or qualified to give you any advice about the advisability or legal effect of its provisions. By signing this document, you're certifying that you have read and accept these terms and acknowledge receipt of a copy of this agreement. Section 17, anything they want you to keep confidential, put it there. You know, they may want you to keep it confidential that they're moving to, you know, I don't know, San Diego, California for whatever reason. Exhibits or addenda, if you have any exhibits or addenda, you can attach it here. Remember, anything that is an exhibit or addenda should have the word exhibit or addenda in the title of the form. And then this is special stipulations. And this again goes back to lines 124 and 126, 124 through 126. The seller is either going to authorize you or not authorize you to tell people that they have offers on their property. Okay, you've got to get this in writing to protect yourself. Please, please, please do this. Okay. And that, ladies and gentlemen, is the end of the listing agreement form. I hope that you learned something. If you have any questions, you can always shoot me a message on Facebook or email me or text me or ask your broker. So thank you very much. I certainly appreciate you, and I will